Good morning, and thank you for joining us for today's webinar. During the next 90 minutes, we'll be looking at the Protected Disclosures Amendment Bill 2022, which, as you're probably aware, transposed the EU Whistleblowing Directive into Irish law, and a number of different areas that relate to the changes brought in by the new legislation. My name is Charlotte Charles, and I'm responsible for customer success and growth for EQS Group's Irish, UK, and Dutch clients. I'm delighted to introduce today's panel, which is made up of Maureen Kelly, Internal Audit Director at Mazars, Kevin Hart, an expert in fraud, corruption and whistleblowing at the Fraud Prevention Training Centre, and Raphael Roca, Partner Success Manager at EQS Group. We'll start off with a short overview of EQS for those of you who aren't already familiar with us, and then I'll hand over to Maureen, Kevin and Raphael for the main discussion. They'll be covering an overview of the new law, internal reporting, and the benefits of a good whistleblowing system. And then, of course, we'll also have time at the end for questions. Before we get into this, just a quick bit of housekeeping. So on the webinar panel, you'll notice the Q&A box at the bottom. So please do use this to submit any questions you may have. And as I say, we'll cover these at the end. There's also a resources section, which you can use to download some useful materials. And on the right-hand side, you'll see a short survey, which it would be great if you could complete when you get a chance. And just to mention as well, we will share the slide deck following the event, as well as the recording. Okay, great. So let's get started. For those of you who are not yet familiar with EQS Group, we're an international cloud service provider, headquartered in Germany and listed on the Frankfurt Stock Exchange. We now have more than 600 employees worldwide, and through our range of investor relations and compliance solutions, we support more than 8,000 organisations around the world. A key component of our offering is our EQS Compliance Cockpit platform, and within the platform are a number of solutions for things like managing policies, gift and entertainment requests, as well as conflicts of interest, and also our flagship product Integrity Line, which is our digital whistleblowing software. I won't go into too much detail, but just as a high-level overview because it's relevant to what we're going to be talking about today. So Integrity Line is a highly scalable, user-friendly digital whistleblowing system, and it's used by companies ranging from a small handful of employees right the way up to tens of thousands of employees around the world, particularly in terms of complying with the EU Whistleblowing Directive. If you'd like to find out more about the system, you can click on the Request a Demo section at the bottom right of your console and follow that through there. So now I'd like to hand over to Maureen, who is going to kick off our main discussion.
Thank you very much, Charlotte. As Charlotte mentioned, my name is Maureen Kelly and I am a director in Mazars, and my specialist area is investigations, both protected disclosure investigations and statutory investigations. So on that basis, I hope that I can actually impart to you some useful information in relation to the new Protected Disclosures Amendment Act 2022. What I'm planning on covering within this presentation is what the benefits are of a good whistleblowing system, just to give you an idea of the deadlines that the new legislation has imposed, to give you an overview of what actually is a protected disclosure and who can make such a protected disclosure and what kind of systems you need to have in place in order to comply with the legislation. Just to hit on the various elements, and what I will be doing is it's very much an overview, I'm afraid, and that's actually restricted by the amount of time that we have available today. But what will be provided to you is a download available which gives details on all of the supporting information you need to know in relation to my presentation today and the requirements of the Act. But if anybody has any questions or queries, feel free to ask them. And also I can be contacted after this presentation to provide any further detail anyone should need. So you're looking at the moment at a slide which is entitled Benefits of Whistleblowing. Now, I believe that a good whistleblowing system is a very positive thing for any organisation to have. You'll see there a few statistics in relation to it, that more than 46% of fraud and corruption is discovered by whistleblowers. So by having a good whistleblowing system within your organization, you're helping the profitability of your organization. You're also enhancing the views of the stakeholders involved in your organization as regards you being an ethical and transparent entity. And that does result definitely in higher good staff retention. So there's a huge amount of positivities around having a good system, having it, and importantly, communicating it and communicating your support of it. And having these systems in existence, we're all seeing in the media the negative impact that whistleblowing to the media has. So if you have a good internal system, you are mitigating that risk that people will go external to the media. So there's a lot of positivities around having a good system, and importantly, communicating well that good system. So if we then move on to, okay, well, what is the Act? What does it require? What are my obligations? So the new legislation commenced on the 1st of January 2023. And at that point in time, all entities with 250 or more employees had to have in place a internal whistleblowing facility. Now, I would also point out that there are certain sectors that, regardless of the number of employees they have, had to put this a system in place from the 1st of January. And just to give you a brief overview, those are entities in the financial services sector, if they're involved in those markets or products, transport safety, protection of the environment, offshore oil and gas operations are also impacted. So those kind of entities, regardless of the number of employees, had to have these systems in place from the 1st of January. And then, as we progress through the year, on the 17th of December this year, all entities with 50 or more employees will be obliged to have in place whistleblowing systems. The legislation also introduces some new time frames, deadlines, and I'll give you an overview of that as I progress as well. So what is a protected disclosure? This slide gives you an idea of what that is. And essentially what it's saying is that a protected disclosure is when a worker, and now referred to as a reporting person, and I'll give you a little bit more detail on that, becomes aware in a work-related context of a matter that they have a reasonable belief may be a wrongdoing. Now, an important thing to note in the new legislation is that interpersonal grievances have been specifically excluded from the legislation. And Kevin will be providing you with further detail on how we actually consider the impact of any reports that may not actually be protected disclosures, essentially a triaging system. But I'll leave Kevin to give you further detail on that. So what is information that is relevant? It's if the worker in a reasonable belief and it comes to them in a work-related context. So those are important elements of what a protected disclosure is for you to keep in mind. But there are quite a number of new broadenings of the legislation that people need to be aware of. So the relevant wrongdoing, what's a relevant wrongdoing? Well, that definition has been broadened out considerably. And a relevant wrongdoing now can also include, well, it always included an offence. It now can, it could be a health and safety issue. It could be fraud, as I pointed out at the beginning, or what's termed in the legislation, improper use of funds. It can also be something that pertains to an abuse of the public procurement system, or it can be an offence under consumer protection legislation. And it also can go into the areas of protection of privacy. So what is considered to be relevant wrongdoing, as the term goes, has been broadened considerably. As I say, detail is provided in the additional documentation that we're giving to you. And then we need to talk about a worker. A worker is now termed a reporting person. And what's important here is, well, it's been broadened considerably. It's not just your employees. It could be your consultants. It could be a subcontractor. It could be a volunteer. It could be a person who's not even yet recruited, but the information that they find on a suspect breach has been acquired during the recruitment process. So it has broadened considerably as regards who can be a reporting person. And it is important to note it can be a current or a past reporting person. So, for example, an individual working in your company retires. During their employment with your company, they became aware of something which they felt was a relevant wrongdoing, but didn't feel secure enough to say anything about it during their employment. They're still entitled to make that protected disclosure after they've retired. So it's to be aware of this increased broadening out. Also, what the new Act has done is it has broadened out what is considered to be penalisation. So we would in the past have, had a standard broad understanding. Okay, what are we talking about penal? Well, you've sacked the person, you've suspended them, and it's on foot of their protected disclosure. But it's been broadened out now to cover things like threats of reprisal, discrimination, blacklisting, early termination or cancellation of a contract. So this could be if the reporting person is a supplier, which also fits into the category of a relevant reporting person. And if you then, as a result of a protected disclosure, stop doing business with them, that also falls into penalisation. So you can see that's broadened out considerably. And also the protection against penalisation not only now is relevant to the reporting person, but it can be a third party associated with that reporting person who has been penalised, say a relation, for example. As I say, all the details are in the download that we're providing to you as part of this. So, having given you that very quick overview of the various elements of the legislation there, what are you now required to do as an entity? Quite a cluttered little slide here, I'm afraid, but I'm trying to ensure that I'm imparting as much information as possible. So what you have to do essentially is you have to establish channels and procedures which allow a person who is eligible to make a protected disclosure to make that protected disclosure in a confidential matter. And you have to ensure that those channels, procedures that you have established are secure and ensure the confidentiality. And this is an interesting one, not just of the identity of the reporting person, who we would normally refer to as the discloser, but also any third party mentioned in the report. So it's important to be aware of that change. So if you have existing policies based on the previous legislation, then definitely there's a need to start looking and ensuring that your policies, procedures and safeguards are adequate to comply with the new requirements. You'll see there that your channels have to allow reporting in writing or orally. You can use a voice messaging system. But if the person requests it, you have to actually be able to facilitate a physical meeting within what's termed a reasonable time frame. And it's important to note that your systems have to be in compliance with the EU data protection legislation, and that your records have to be maintained and maintained within line of the data protection legislation. Sorry, getting a little bit dry at the mouth. I did mention that there were new timeframes and deadlines involved in this legislation. So the first one to be aware of is that you must acknowledge in writing receipt of the protected disclosure to the reporting person within 7 days. So if you feel your systems are not up to this, then it's time to look at improving and updating those systems. Now, then what are you obliged to do? Well, your next deadline is a 3-month deadline. we would recommend you actually are more proactive than 3 months, but that's the legislation. So what have you to do? You've to do an initial assessment of that proposed protected disclosure. I won't say it is one because you still have to assess whether it is or not. And what you're doing there is you're establishing, is there prima facie evidence that this is a protected disclosure? Or is the information you've been provided with actually leading you more to believe that this is something that can be dealt with under another procedure of the organisation? Perhaps it's a grievance, in which case it should be dealt with under the grievance procedures of the organisation. Now, if that is what you establish, then you must communicate with the reporting person and advise them, we've reviewed, we've triaged, we've identified, and therefore we are now referring this to our grievance procedure, and perhaps you'll be saying our HR department will be in contact you shortly or within a specific time frame. Or you could be going back to them and saying, yes, we've reviewed this and we actually consider that, yes, this is a protected disclosure. So on that basis, what will you be doing? You will be maintaining an open line of communication with that person. I would advise more frequently than the 3 months, because remember that one of the main benefits of having a good procedure in place is that you are preventing open exposure of your organisation to allegations in the media. If you're dealing with this appropriately and communicating frequently enough with the disclosure, then you are mitigating the risk of that happening. So what kind of information are you giving to them? You're giving them information on the action that you envisage or have taken in order to follow up on this. So you're just keeping them up to date. You're not necessarily giving them very detailed information, but you're informing them what is relevant, that essentially something is happening here and this is what's happening. And you continue to maintain that communication with the person. The legislation says in writing at intervals of 3 months until the case is closed. I would recommend more frequent updates in order to reassure the discloser that something is actually happening. So these internal reporting channels, they have to be provide feedback. They have to allow for the follow-up that's going on. I feel I have already looked at this slide. I have. Sorry about that. Yes, we're going in the wrong direction. So there are other things that you need to consider as well in relation to protected disclosures. And one of the primary things, I've given you the carrot, and now I'm going to talk to you about the stick. So what happens if you are not in compliance with the legislation? Well, these are essentially the headings on the areas where you're considered to have committed an offence. If you hinder or attempt to hinder reporting, if you retaliate against the reporting person or a connected third party, as I've already referred to, if you bring vexatious proceedings against a reporting person or a third party, if you do not maintain the confidentiality requirements of the legislation, or if you fail to actually establish the channels that legally you were meant to have in place from either the 1st of January this year, or if you're one in the smaller entities categories, the 17th of December this year. All of those are things that are considered to have committed an offence against the legislation. And those offences can be penalised through fines and or imprisonment. The detailed handout has details of what level of fines and what level of imprisonment each offence occurs, but hopefully that won't be something you need to consider, but just there for information purposes. So I hope I've given you a bit of an idea of, who is impacted by this, who can actually make a report, what is a protected disclosure, and then what kind of protections should be in place. So the main thing that I am saying here is that you need to consider having good systems in place, the benefits of having those good systems in place. You need to be aware of what you need to do in order to comply with the legislation. And importantly, in my opinion, and based on statistical evidence, communicate this as well as you can, because it should be viewed as something positive that contributes to the health and profitability of any organisation that has it in place. So what can we in Mazars do? Well, as I mentioned at the beginning, I've been involved in investigations for quite a number of years now. We're statutory investigators appointed by the Charities Regulator and the Approved Housing Bodies Association, Approved Housing Bodies Board. And we have, as a result of that, developed quite a range of protected disclosure policies and procedures that can be adapted to the needs of any organisation. And we have, as a result of our work over the years, a good team of trained and experienced investigators who can assist you both in the area of investigations if necessary and in the area of doing a gap analysis. So have you got a system in place from the previous legislation? How is that transitioning into the new legislation? Are you still ticking all the relevant boxes? Do you have any, if you have no policies or procedures, we can certainly provide ones adapted relevant to your own organisation. And then, as I've mentioned, the importance of communication and the importance of ensuring that people within your organisation and stakeholders, because remember my broader reference to who a reporting person can be, that all of those individuals can access secure whistleblowing systems and are aware that your organisation feels these are positive procedures, that you promote them, and that from the top down within your organisation, there's a supportive culture in relation to whistleblowing. So we can provide training in that area, awareness training, and as I've mentioned already, investigations. So I hope I have enlightened you as regards the elements of the legislation you need to be aware of. And I hope that I've emphasised enough that I really do believe this is a very positive piece of legislation, which when appropriately applied to your organisation will actually have a beneficial effect upon your organisation. So thank you very much for your attention. I hope I haven't gone too fast through that, but I want to give a good opportunity for questions at the end. And I'll now hand you over to Kevin, who will enlighten you on the internal reporting in relation to protected disclosures. Kevin?
Excellent. Thank you so much, Maureen. Good morning, everybody. Thank you for taking time to join us today. What I'm going to try and do today is get really practical. We've heard from Maureen some of the nuances and some of the details of what organizations need to be aware of. And just reflecting on one of the major points that came to me from Maureen was communication. So communication starts at the highest level in the organization, setting the ethical tone for any organization. There's so then driving that ethical tone into policies and procedures is the next step. And then logically, everybody needs to be aware of their responsibilities for the organization in terms of what the policy says and what to do about it if they come across a relevant wrongdoing or something that they know isn't right. And how do you know if something's not right? Well, people need to be made aware these constitute wrongdoings and these are okay, just to give everybody the opportunity to report what they know. We're trying to build trust with everybody in the organization to understand they do have a responsibility. It's not a heavy burden, but when they do come across something, providing the right safe reporting channel is what we're trying to establish through today's discussion. So I'm going to start by running a quick poll. I just want to understand from the audience, what do you currently have in place for managing whistleblowing reports? So hopefully up on the screen is the first poll. So go ahead, choose what you think is most appropriate for your organization, and we'll have a look at the results in a few seconds. Please remember there is a Q&A function. If you have any questions, just pop them in and we'll manage those questions towards the end of the presentation. That's going along really well. A few more seconds. Okay. There we go. There are the results, hopefully coming up on the screen. So just over 3/4 of everybody participating today manages the whistleblowing reporting internally. 15% are fully outsourced, including a web-based platform. Fantastic. 7% not aware of the system to manage whistleblowing reporting. That's quite okay. This is the reason for today, is to just raise awareness levels and give you some insights into practically what can be done. So I've structured my part of the presentation along the lines of Q&A that I often get from clients and other stakeholders that are grappling with how to actually get really practical with implementing the solutions in their organizations. So the first question is there a specific profile needed for case handlers? If you recall, it goes through the reporting system and it lands up inside your organization, hopefully. Who is the best person that should be looking after the reported matters? So a couple of aspects that you need to consider. Does that person that you've mapped to be sort of the champion in terms of receiving protected disclosures, are they competent in terms of being able to understand what's coming in and what to do with it? Will they apply due diligence to the matter? In other words, manage the confidentiality of the reporting person and the actual substance of the matter? And will they very essentially be impartial to the matter? So think about currently who's managing that in your organization. Make sure that those aspects are adequately managed. And I think impartiality is very key. If you have somebody that is very much part of the organization and very connected to the people, you start to lose a bit of impartiality. So just reflect upon that. Your case handler needs to be somebody that is very comfortable in the organization. Remember, they may be seen as sort of an outsider type person, or the sentiments that have been portrayed to me is, I don't really want this role. It's going to create a bit of awkwardness in the firm. So just a few things to reflect on there. Can you share case handlers between different EU entities? So your organization may be a multinational organization. You can share resources if you're in a smaller organization with less than 250 employees. All your EU entities with more than 249 employees will require separate case handlers to be assigned following the case governance principles. So have a look at what you currently have in terms of your policy and procedures and see if everything stacks up. Can a head office outside the EU run the whistleblowing function for its EU subsidiaries? Let's say, for example, you have a head office based in the USA, and you will need to set up a separate whistleblowing function within the EU territory that you are operating in if you have more than 249 employees. So that's pretty straightforward. Are there case handling deadlines? Maureen did touch upon this, and we had a Q&A question come through. 7 days, we refer to 7 calendar days. So the clock starts as soon as that report is received. You have 7 days to acknowledge receipt of that report coming in with the reporter or the whistleblower. Okay, are there any risks related to improper case handling? Absolutely. Unfortunately, being able to manage those cases is critical from the very first minute that you receive. I reflect on one of the recent projects based in the Middle East, very big gigacity project, very complex, thousands of people and contractors all connected, lots of suppliers, lots of moving parts going on. You've got to be able to quickly assess what it is that comes in, who is impacted, and have a plan of action to inform the relevant parties about the matter. Obviously, keeping confidential the name of the whistleblowers is vitally important. So if you don't have a very clear case handling procedure currently, it's time to actually look at it, spend some time, spend some effort in making sure that it stacks up against what is practically relevant to achieve compliance with the law. A couple of other positive factors that come out of actually making sure your case handling is done is you're going to reduce your reputation risks. There's nothing worse than a whistleblower or somebody making a protected disclosure getting nowhere. They feel very frustrated. They feel that they're not being heard. Perhaps it's a health and safety report that's come through, and they're aware that if nothing happens, there's going to be potential danger to life. So that often pushes whistleblowers to report either to competent authorities or even further into the public space. And we'll touch upon some of the immunities that can be triggered when certain conditions are met. As I've just discussed, public disclosure immunity does prevail. So we're just going to pause for a moment. What are we talking about when we talk about public disclosure immunity? So in order to gain immunity from reporting into the public, there are a couple of key things that should be in place. So first of all, the person should be reporting to the proper authorities, okay? And depending on the sector or industry you're in, there may be the right authorities defined in law or regulations, and that disclosure should be made in good faith. So good faith reporting is key all round. It goes back to the communication that needs to happen within your organization. People need to understand that this is not an opportunity to disparage somebody else because they've been hurt in an organization. Good faith reporting should prevail. Disclosures should be made in the public interest. The information should be disclosed, should be of public interest, and have the potential to reveal illegal activities or serious misconduct. Okay. The person should follow the proper reporting procedures. Again, if the person in the organization doesn't know how to actually properly report, you need to make sure that they are aware, and they should be following the appropriate route. The person should have exhausted all internal reporting channels. Okay, I think it's very important that you want to be able to control any matter that comes to your attention internally first, before it makes its way into any competent authority or further into the public domain. So the best thing you can do is make sure that you have a very simple and clear way for people to report, something they can trust, and something that provides the feedback channels that are required in terms of the law. The 7 days for acknowledgement and the 30 days to provide feedback, further feedback on what you're doing about the reported matter. The person should be of any personal gain by making the disclosure. So again, all of these aspects need to come through in your communication, through your training and awareness programs that you should be thinking about. There should be protection from retaliation. The whistleblower should be protected from any form of retaliation, including dismissal, demotion, harassment, and national laws in terms of the Irish law should provide effective remedies for retaliation, and they do. And then very importantly, confidentiality. The whistleblower's confidentiality should be maintained and their identity should be protected. Another quick poll. In your organization, do you perceive that employees won't report if they can't do so anonymously? Either agree or I don't agree. So go ahead and give that one a go. Okay. Let's see how we're going. Excellent. I see some good results coming through. Okay, I'm going to share. Go ahead. I'm going to share. I think it'll still come through. Excellent. So that's the result I was hoping for. So when you do have a facility to report anonymously, employees will actually more often than not use the reporting functionality. So let's touch on what do we mean by anonymous reporting, okay? In Ireland, there is no current obligation in terms of the law on an employer to accept anonymous reports. However, where the employer does accept anonymous reports and where a worker's identity subsequently becomes known, the protection against penalization will extend to them. So it's very important to consider. I do have often queries coming through from clients saying we don't really want to make anonymous reporting available. So the downside of not providing an anonymous way of reporting is the reporter might become frustrated and go outside of your organization. As I mentioned a little bit earlier, trying to manage the matter that's come through internally is much better than trying to have to explain to authorities if the report goes outside and you're unaware of it. You kind of caught unaware. So as I've mentioned, it is not illegal, but reputation risk is at stake, and you want to be able to control as much of that as possible. Are third parties eligible for protected whistleblowing? So very much yes. Okay, some of the specific third parties that you need to be aware of in terms of making the reporting channel available are your suppliers. Most organizations rely heavily on their supply chain, so they're often asked to sign up to your ethical posture through the terms of business that you have with them. But also think about contractors, so folk who come in and out of your business on specific projects. They're also eligible for reporting. Applicants, so if somebody's come along for a job interview, whether they did or didn't succeed in the job, they still have the ability in terms of the law to report something they are aware of about your organization. And of course, employees, regular employees, all covered and eligible for protected whistleblowing. Can the whistleblower refuse access to his report beyond the case recipient, right? If you think about the best model for reporting, you have a very clear channel of reporting. You receive the report. The very first person is what we call the case recipient or the case handler. That person should have the skills that I mentioned earlier to have a look at the substance of the matter and immediately be able to triage that matter into either it's a interpersonal grievance and it goes into that channel, or the substance of the matter, be it a fraud, be it a health and safety issue, whatever it may be. And that takes a matter of minutes, not hours or days or weeks, a matter of minutes. You're able to distinguish the substance of the matter. But the question here is, if that recipient receives the matter, the whistleblower or the person making the disclosure has only authorized that specific person to be aware of the case. You will need, in terms of the law, permission from the whistleblower to disseminate that case to other people in the organization. So just have a look at your current policy and procedures. If it doesn't address this aspect, it's an opportunity to go ahead and do that. And our third and final poll. Is it very important to be able to properly assess a report from a potential whistleblower? So having an independent and experienced professional handling the initial assessment is important. Do you agree with that statement? Do you agree that the person needs to be independent and experienced as the person receiving the report? Either you agree, in other words, assessing a report should be in the hands of an independent expert, or I don't really agree, it's not necessary to have an independent expert assess a report. Based on everything we've covered so far, what is your opinion? I see some results coming through, thank you. Excellent. And again, there's no right or wrong answer. I want you just to have a look at where you sit on in terms of agreeing and don't agreeing. Learnings from today, take them back, have a look at how you currently do your reporting, and are you covered, would be the essential question to ask at the end of the day. Now, in terms of the reporting channel, can whistleblowers abuse their rights? Unfortunately, yes, they can. One example is the staged whistleblowing to trigger the reverse burden of proof. Okay, it will always be up to the organization to show that there is no link between the act of whistleblowing and any negative decision against the whistleblower, such as dismissal, contract cancelizations, demotions, missing a salary increase, amongst many others. Essentially, what that does is it says to the organization receiving the protected disclosure, you need to show that your actions were not as a result of any one of the negative decisions that the whistleblower has been impacted with. So that's why it's called the reverse burden of proof. Do whistleblowers have full protection against retaliation? Yes, they have, unless you can prove the use of false declarations. In other words, the person is using the system for personal benefit in some way, and in fact, the facts of the matter are false. Going on to actually some of the practical matters. So how do you implement a reporting channel that achieves the best protection for yourself as the organization, but very importantly for the whistleblower in terms of compliance with the legislation? A web-based reporting channel, one of the questions that we often get, is it an expensive thing to go and set up and run and maintain? And the answer simply is no. Once you determine the cost of operating a manual system, so think of the current people involved, including the cost of errors and reputation, errors in terms of the way the reporting is handled, perhaps a breach of confidentiality and what that may mean, and the subsequent costs flowing on from that. Once you have a look at the sort of basket, I guess, of costs to run something in a more manual system versus going across to a web-based reporting system, you'll soon see the financial investment is more than justified. Are the rules applicable to small organizations with less than 50 employees? No, not at the moment, but small organizations will be expected to inform their stakeholders that they, in other words, the potential whistleblowers, can report into competent authorities. So just be aware of that. And then a question I often get, it's a funny question, but it's actually quite serious. Can I copy and paste a whistleblowing policy from the internet? Well, of course you can, but our recommendation is don't do it. It's always best practice to have a professional organization, as ours or a law firm, develop it to match your internal organizational structure and the risk appetite. It has to blend nicely in with your other policies that you have in your organization. You'll also need to inform all your internal and external stakeholders about your whistleblowing policy. Again, communication is vital to drive this home. So I've reached the end of the typical and very good questions that often come through. Just to sum up, there is a very practical way to manage whistleblowing or protected disclosures. Have a look at what you currently do. Have a look at the legislation and what's expected in terms of timing, confidentiality, and protecting a whistleblower. Remember, this legislation is designed to encourage people, and I think most organizations would appreciate understanding that there are issues that they're unaware of but come through the whistleblowing route. As Maureen mentioned, a lot of fraud and corruption is revealed, it's detected because of the whistleblower tip-offs. If you're in an industry that has serious health and safety rules that need to be followed, and you're unaware that perhaps at a construction site there's abuse of those safety rules, you would love, I imagine, to be aware of that sooner than later, and to be able to take corrective steps before somebody's life becomes endangered. It's an extreme example, but this is the purpose of the legislation, is to protect not only the whistleblower and the organization, but everybody connected. So thank you so much. Please go ahead with Q&A as we're going through the rest of the today's presentations. Thank you. Over to you, Rafe.
Excellent. Thank you, Kev. Appreciate it. So good morning, everybody. So I'm Raf, Partner Success Manager at EQS. So my remit covers Netherlands, UK and Ireland, and overall I sort of aim to help clients identify requirements and then ultimately consult on the most appropriate solution for them. So my segment, it shouldn't take more than 15 minutes. I'm going to be covering off firstly challenges that organizations typically face through our own experiences. I'll then move on to what whistleblowing systems in practice, so mailbox, phone hotline, etc. And then I'm going to discuss what an effective whistleblowing system looks like. And then finally, what a successful project looks like from our perspective. So I wanted to just sort of highlight this slide, and this is just basically highlighting the key regulations that Maureen and Kevin have kindly talked us through. And essentially, I want to finish the presentation by touching on these individually and highlighting how a whistleblowing software can ensure that you are compliant with each of the key regulations. So I'll start off by discussing what challenges do organizations typically face in managing an effective reporting system. So firstly, we find from our experience that many organizations are faced with employees who are unsure of how to report effectively, especially in a secure way. Many are overwhelmed with the concept of installing a hotline that complies with the law, and of course the time that it could potentially consume. In truth, working with an external partner to implement a solution, it provides businesses with a wealth of experience from the thousands of implementations that partners typically do. And also allowing the fact that a configurable platform is available, it's a relatively easy setup. There's always the possibility to purchase off-the-shelf software product, or perhaps a more bespoke for the larger opportunity. So there are the options depending on where you are and your timescales. There's also the confusion that comes from having no central overview of a compliance process. It makes it very difficult to sort of identify your current state of compliance. There's also the concern of becoming inundated with unjustified accusations and then continually growing. So, for example, perhaps salary dissatisfaction. So when I speak with clients on this topic, I think it becomes clear that there's not entirely a way to completely deter these issues. On the other hand, I think what we sort of suggest is it's still certainly better to have the ability to filter into legitimate cases than to receive no cases at all. And then finally, the growing young workforce who naturally do favour the different forms of communication. I think it's certainly necessary to adapt and adopt these methods to suit the new generation. So now I'm going to touch on sort of talking about the traditional whistleblowing methods that have been prominent, and I'm going to touch on their sort of benefits and the potential hurdles that come with them. So a report mailbox, I think it's fairly evident and obvious to say that the majority of organisations aren't using this method now. I mean, the entire dialogue and availability is hindered. So moving on to sort of phone hotline. So we can certainly agree there are benefits to utilising a phone hotline, especially if that phone line is a professional sort of system in place. There's always that direct conversation and feedback. That's an obvious positive. The challenges that we see arise, though, is through the international ability. We've seen from clients the hurdles of language barriers, for example, and then occasionally interpreters have to be included, which of course then raises the question of security of information if you haven't done your due diligence with that interpreter. Additionally, there is the risk of anonymity or connection and sound problems that can further exacerbate an issue, especially if that complaint is urgent. So we are seeing a steady trend move away from phone lines leading to digital. And as I touched on earlier, that shift from telephone to communication software has certainly been accelerated, especially by external factors such as COVID, leading to younger people and employees in general preferring that digital approach. So then I move on to email system. Again, many organizations I've spoken to utilize this. It's easy to implement, it's high profile, and it's relatively inexpensive. So we've sort of identified three key differentiators, so to speak. Firstly, with email system, your data is exposed to security of data protection risks, especially considering there can be a lack of encryption on email. So ultimately means that emails can be read, they can be amended, therefore making neither the transmission or processing of reports audit proof, which of course is essential. We also see that employees may not necessarily trust email, which leads to less of that speak up culture. And then finally, it doesn't really allow for that efficient case processing, which Kevin's been discussing a little bit there and Maureen. So perhaps once they send an email, then they will have to log cases manually, or they won't have a case management system in place at all. So effectively, it leads to inefficient case reviews. So all these considered, the form of reporting system most widely contemplated and implemented now is certainly digital. And it's threefold here. I suppose it provides flexible intake methods. So you have the web and mobile portal, you have a case management system where all the cases are managed in a securely encrypted environment. And then finally, you have all the reporting and metrics on the back end as well. So overall, it just provides a much more flexibility of a fully reliable system. So now I'm going to touch on what a whistleblowing system means for companies. So as we've been talking about, in order to fully comply with legal directives, organizations are now considering implementation of that more robust system to ensure that they are fully compliant. It of course protects both your company and employees from fines and imprisonment. And I think a really relevant one, which is a bit of a buzzword now, and I think it sort of differentiates you from different businesses, is that speak up culture. And through our experience, we are seeing certain fundamentals that crop up a lot where employees don't feel comfortable to speak up. So for example, many think that an action is common practice. There can be a lack of confidence in their organisation that corrective action would be taken. Many are simply afraid that reporting may cause bad blood between their peers or perhaps management, leading to them perhaps not getting a promotion in the future. And also, I suppose leading on from that, many believe that senior management or the board were already aware of the issue. So all of these suggest that an anonymous, sophisticated case management system is the most appropriate solution to alleviate these fundamentals. And then the final two, we are seeing, and I'm sure many of you can agree, that many companies are increasingly aiming to collaborate or partner with organisations that have a solid governance structure and ethics. I think partnering with those organisations is sort of the forefront of many people's minds. And then finally, again, just reiterating, just protecting your reputation, protecting yourself from reputational damage or potential financial loss. So I wanted to highlight now what a successful project sort of looks like, again, from our perspective. So following EQS's sort of success of becoming a leading solution provider for whistleblowing software, we've determined almost best practice and what makes a digital solution the most effective. And what it boils down to essentially is just involving those key stakeholders initially and throughout the entire project. And I've given a few examples here. So if I start with IT, so typically IT cloud-based software, it doesn't require integration into IT infrastructure. However, as you can imagine, IT need to validate the security of this system, the need to have the most robust security possible. And also leading on from that, in terms of data protection, of course, for most companies, this is of paramount importance. So a digital platform, it should be easily demonstratable. However, privacy officers or data protection officers, they should be aware of where that data is being held. And then, of course, the question needs to be asked, how are you going to be managing these cases? Are you thinking of potentially triage centrally and then distribute to case managers, or use the system more specific for a department such as HR? So again, our recurring advice here is to include the various stakeholders in the entire process. And I appreciate repeating myself a little bit there. It's a recurring theme for us, and that's where we see the most success. And then finally, around communication. So again, we sort of recommend letting your comms team know about what's being drafted so that they can communicate out to employees. Various methods to do this. Every company is different, but all hands calls, there's various media channels, or perhaps you already have a HR process already in place. So I'm coming to the end now, and I suppose just to sort of cover off here, overall with EQS's experience within the compliance market, we currently have over 3,000 customers, predominantly just on our integrity line, which is our internal, this is our digital whistleblowing software. And what that suggests is that utilizing a digital platform is the most streamlined, accessible, and effective process to promote not only employee satisfaction, but also case management with regards to whistleblowing. And also, of course, ensuring you are fully compliant with the EU directive. And again, I don't have to touch on all of these individually, but I wanted to highlight how, as an example, our platform will ensure that you're 100% compliant with those 7 key regulations and others as well. So that covers off me. So thank you again. Appreciate everybody's time, and can move on to Q&A. So thank you, Charlotte.
Apologies, it took me a moment to find the mute button to turn myself off mute there. So thank you very much to Maureen, Kevin and Raf. That was really interesting to hear all the points that you've covered. So now it's time for us to take a look at some of the questions that have come in so far. And just a quick reminder that if you do want to submit a question, you still can do so via the Q&A box at the bottom of your webinar console. But we've had quite a few that have come in already, so let's take a look at some of those. So the first one, let's go for, is it a legal obligation or best practice to have an external reporting channel for workers who do not want to report to an internal source? Maureen, can I come to you for that one?
Yes, certainly. Okay, so essentially what the legislation is saying is that it's designed for a person to report internally is the preference. So you're encouraged to report internally. If you wish to retain, when I'm saying you, I'm talking about the discloser. If the discloser or reporting person wishes to retain the privileges and entitlements to protection of the legislation, then they must report internally and can only choose to report externally if they have first reported through internal channels and received no feedback or follow-up within the required timeframes as specified in the legislation, or internal channels are unavailable or inadequate. So essentially what the legislation is saying is, if you as an organisation comply with the requirements of the legislation, set up appropriate internal reporting channels and respond within the required timeframes, then that person may not actually report externally. And when we're talking about external reporting channels, that is not your obligation as an organisation to set up external reporting channels. External reporting channels would be reporting to the media or reporting to a competent authority. So, for example, if it was a charity, then the person, if the charity didn't have appropriate systems within it, would be entitled to go directly to the charity's regulator and report to them. Or if you were operating in another sector that didn't have a specific regulator, the person can go directly to the commissioner themselves, the Protected Disclosure Commissioner, and make that report. So those external reporting channels are not the obligation of an organisation to set up. Those are, as I say, media or regulators, but that the person cannot use those channels unless they have already exhausted internal systems, or those internal systems are not functioning correctly.
100%, I agree. I just wanted to add on, I think you want to be able to manage anything internally and exhaust all the investigation around that, and make sure it doesn't find its way into the public domain, which would be the worst for most organizations. So making it very clear, making it sort of very clear, if this, then do that, if that, do that. So having that very clearly set out in your written documents and through the training and awareness, absolutely vital. And to encourage people to, first of all, know the system exists, and then how to use it and why they should use it. Those three components together should build a lot of trust into the system that you have in an organization.
Makes a lot of sense. Thank you both.
Excellent.
Great. The next question, Kevin, this may be one for you, as I think this builds on something that you were mentioning during your presentation. So slightly lengthy ones, bear with me here. Regarding the point that you need permission from the whistleblower to further share the report beyond the case handler, from a practical perspective, how is this managed? Is it sufficient to outline your investigation procedures and then require the whistleblower to opt out if they don't want it? Or can you have deemed consent if they make a report, as long as you outline the investigation procedures as part of the reporting process?
I think the first aspect there is, I think, express consent is required. Okay, what you want to do is, from a practical perspective, whatever system you have in place should allow, first of all, a clear communications channel. So it does get a little bit more complicated if the person chooses to report anonymously, and you have a way for them to do that. But good systems, and I think Raf touched on some of them, do have the opportunity to correspond. And what you want to do is talk as much as you can with the reporting person, with the whistleblower. They often do have more information subsequent to their first report. What you want to have internally is a sufficient audit trail showing, first of all, you got the express consent of the person to unshare the information further into the organization, perhaps with legal counsel, whatever, depending on the matter itself, and that you can adequately demonstrate if something does go wrong in the future, you can show whoever's asking, this is how we managed the case. We have a full audit trail. It came in on this date. These are the people that touched on the case. And most of the web-based systems, very good keeping an audit trail, and you're able to produce any report coming out of that. So practical point of view, you need the expressed consent, corresponding and keeping them informed. It can organization, if they are fully on board with the process that you've made clear through your written documentation, and they understand through good communication how you're going to handle the case, I think the results will be better for everybody involved. You'll contain the damage if there is any damage to contain, and you will have less disgruntled whistleblower who'll be less inclined to seek other reporting channels outside the organization. So it's all about making it very clear, simple, and trustworthy in terms of whatever you build in. So if you currently have a system, have a look at those aspects. Does it encourage good faith reporting? Does it encourage a two-way communication with the case triage handler and the reporter? And if it doesn't, then I think it's a great opportunity to relook at how you do things.
Great, thank you. Maureen, Raf, anything else to add before we move on?
No, I think Kevin has comprehensively answered that one. It is really,
absolutely,
as with all of this, it's about clear communication. It's about people being provided with sufficient information that they understand the remit, the scope of the policy, what they can and can't do, and what the obligations on the other side are too.
Yeah, it makes sense. And I guess through that you can build trust, which is what this is all about. Great, thank you. Okay, let's have a look at the questions that we've got. So next one, how are suppliers covered? Is this in relation to EU procurement regulations only? I don't know, Kevin, if you want to come in on that one, or Maureen?
Yeah, I think from my perspective, suppliers should be allowed to use your reporting channel. I think they're a vital part of most organizations. you do have a lot of you have less control, let's say, with your suppliers than you do with employees. But good organizations want to encourage any issues in the supply chain to come to the fore. It's very good business practice, and providing adequate safety in terms of the law for them is only it's a very good aspect to build into your approach to handling the sensitive information. Again, you're trying to minimize the channels that you have. You want to sort of crystallize everything into a central repository would be our recommendation, and just bringing in your suppliers would be a very good idea indeed.
Yes, and if I could add there, it is not just about EU procurement rules. Essentially, you're looking at every person that's actually listed in that reporting person designation, and you're also looking to have as broad an input of information into your organization as possible. So, for example, your supplier may note that something and remember that it is as a result in a work-related context. So your supplier, as a result of their interactions with your company, may notice something inappropriate. It might, here's a straightforward fraudulent, it might be a suggestion from somebody in your purchasing department to the supplier that maybe they gave them a little bit of a backhander, etc. That is an offence. And that is something that you would like to be able to provide your supplier with a good confidential conduit whereby they can inform you of that, because that's only of benefit to your company. And it means that you've got that additional information otherwise you might not have had. Hope that answers it.
I think so. Thank you. Great. Next one then is, so in relation to EU entities and the requirement for an EU-based handling team, the person asking the question is assuming that resources employed by a UK entity are not included in the figure of 249 employees. Is this correct? Does anyone want to
Let's
take
just
that one?
unpack that question.
Sure.
So just rephrase the question. So it's an organization that has more than 250 employees, and some of them are based in the UK.
That's my understanding, yes, from the question.
Okay.
So if we take that as an example.
So you will have to have a reporting mechanism for the EU covered people. So no matter the size. So if it's 250 over, and let's say 150 of the people are in the EU, there will need to be an EU-based, or not EU-based, but an EU whistleblowing or protected disclosure system in place. I hope we got that question the right way around, or at least the answer
I hope so too.
and the question the right way around.
Perfect.
Okay.
Right, what else have we got? So next question then, is it recommended to have a referral to leadership if a person is not satisfied with an investigation outcome?
I think the question is if the dissatisfaction comes from the whistleblower. Would we agree on that?
Yeah.
So Maureen, from my perspective, the amount of information that is shared in terms of the investigation outcome is set by policies of the organization. Obviously, being practical, you want to be able to give the person making the disclosure enough information that doesn't at the same time expose identities of other people involved. In other words, we're not going to be sharing names, but we're going to give them enough information that they feel that the matter has been adequately dealt with. If they're still not satisfied, I guess it goes back to the communication channel, having an open communication channel where they can ask more questions with the case handler or the triage expert, until they get to a point where they're satisfied. I think from a legal perspective, I won't have the answers right now. I don't know if you have any further views, Maureen, on what can happen there.
From a legal perspective, I would need, like yourself, to just go in and drill down into that. But if you're asking, is it recommended, it would be a decision. Now, I'm saying this at the moment, and I'll need to drill down into it. I have a feeling there is a requirement, as I think upon it, for there to be some form of an appeals process. And the main thing there would be that one actually ensures one sets out quite clearly the scope of the appeals process and the system by which it's done. I wouldn't be suggesting to a referral to leadership necessarily. We must always consider, in relation to all of this, maintaining the confidentiality of the system. So I would, Kevin, if you want to contact me independently, I can actually give you a good, proper response in relation to that. But my memory of it is that there should be some form of appeals process in place. But I could be wrong on that, so let me come back to you on it.
Yeah. Just on a related matter, touching on that question as well, most organizations, at least in the public sector, will have an obligation to report on protected disclosures annually. So very, senior management will be aware of the matters holistically, and I think I'm just going to beat on a little bit about making sure that you're able to communicate. That often is where things go wrong. The person reports something and they're in the dark, and then suddenly they see or hear something happen in the organization that they know could be a result of what they've reported, but they're somehow not appraised of it at the right time. So very much how you set about your communication is very, very key to managing expectations and being able to share enough information to keep the whistleblower or the protected disclosure person satisfied.
That's great. Thank you both very much for those answers. Right. Next question is, so we already have a protected disclosure policy in place. Do we need to revise it?
That's a definite yes. If your protected disclosure policy was based on the previous legislation, absolutely. You will have seen from all of our presentations today how much the legislation has broadened things out. And one thing that I have noted from my interactions with people within the public sector is that many of them may, up until this point, have had protected disclosure systems which were available on their intranet. If you now consider the broadening out of who a reporting person can be, as the earlier example, a supplier, a contractor, etc., then the intranet is no longer a suitable facility for that, because these people are external to the company and therefore may not have access to that. So the requirement is that you put appropriate systems in place and that they are accessible to all who are entitled to actually make a protected disclosure, and that they are easily understandable, that the information on it is understandable. So yes, definitely, there's a need to review if your policies and procedures were based on the legislation prior to the 1st of January this year.
Great,
Kevin,
thank you very much.
No, I 100% agree. And I think the whole point of policies is to drive behavior. So how you encourage people to change behavior is by making it very clear, making the procedures linked to the policy absolutely, actionable, and then raising awareness through proper formal training is the way to implement a newly, or let's say an adjusted policy that complies with the law into practical actions throughout the organization. We want it to become something that is not seen as a, we're going to tell on people in the organization. It mustn't be seen as a negative thing. It must be seen as a positive, and become part of the culture. Now, this is going to take a bit of time. In most organizations that I've worked with, there isn't a culture of openly talking about what you know. It's more that everybody knows what's going on, but nobody says anything. And therefore, that activity remains in place. We're hoping that, through these awareness sessions and where people get more comfortable that there are good reporting channels available, easy to implement, you can actually get that culture changing fairly rapidly.
Brilliant. Okay, we've still got a little bit of time, so let's go through some more. Okay, so next one. The DPER interim guidance says it is mandatory for prescribed persons, and I'm guessing this is supposed to stand for commissioner because I've just got COMR, to accept and follow up on anonymous disclosures. Is this correct, or is it only internal reporting that there is no obligation to accept anonymous reports?
Okay, I can answer this one. My presentation was very much geared towards people in the private sector, and the impact in the public sector is, that deeper guidance is correct, because in the public sector, all entities have been advised that they must actually accept anonymous disclosures. So in the private sector, it's a choice of the organisation. But in the public sector, yes, facilities have to be in place in order to accept anonymous disclosures.
Great, thank you. Yeah. Anything else to add, Kevin? Or
no, I think that's 100%. Again, anonymous reporting from the private sector perspective is very much to encourage whistleblowers not to go outside with the information. You want to be able to deal with it as internally as much as possible. So I've mentioned that a few times, and it very, very, very much is a critical aspect to consider. Having your dirty laundry out in the public domain, we want to avoid that by all means.
Yeah, definitely. Okay. Then we've got, so where a verbal report is made to a manager, is it okay to direct them / the reporter to utilize the formal reporting tool in order to be afforded the full protections from the reporting tool and legislative requirements?
I would say so, yes. Again, I think that needs to be addressed in the policy. I have a few clients who only allow reporting to happen, person to person. So that begs the question, well then, the ability to report anonymously, obviously that can't apply at all. But you start eroding other confidentiality aspects as well. You're less able to contain the communication, because that person that you reported to may go and speak to another person, etc., etc., and so suddenly the identity and the matter itself is more widely known than it ought to be, less easier to contain. So in those circumstances, once the organization has put in the correct channel, the policy clearly says you can go to your manager. However, there is this confidential reporting hotline or whatever it is available. So we want to be moving people to consider more confidential reporting, and training of the person being the manager receiving an in-person report is very critical as well. That management level employees should be aware of what to do. So it goes down to our training and awareness. If you're a manager and one of your team comes to you with a confidential matter, how do you handle it? Step 1, step 2, step 3. So really it is a holistic approach to whistleblowing. Not only may you have a good channel, electronic, web-based, whatever it is, but some people may be comfortable reporting in person to their manager. That person needs to know what to do with that information. Maureen, do you see anything on, with some of the clients you work with, currently the preference for using online type tools versus in-person reporting? Have you noticed any sort of, is there a majority of clients that still have written in, person-to-person reporting, or are we moving towards something less one-on-one?
I think that what I'm seeing and what I would recommend, it's all about clarity of policies. So I think, as you've already said there, Kevin, it's about having good systems and procedures in place, and most importantly, that everybody's aware of those good systems and procedures. I'm seeing many organizations who are doing in-person, and that actually happens to be just the way that these reports flow, that a person finds something, they're unsure about it, they go to their trusted advisor who happens to be their manager. But the important thing is then that manager is very aware and can easily access the policies and procedures and can actually then know, okay, I can take this information and process it onwards, or our system and our policy says I should refer the person to XYZ, be it another person, as in the protected disclosure manager, which many organizations have, or to an online system. But really, I think, as you've said, the vital thing here is that it's clear. What is our policy? How do we handle it? So that nobody is ever in a position of not knowing how to respond to something that's brought to them. Because, as I say, in real terms, especially when it's something like a fraud or like a person being asked to do something that they feel isn't right, they tend to go and chat to their manager about it. So that manager needs to know what to do next, essentially.
Great, thank you. And I think just to add very briefly, so I've seen it with some of our clients as well, they use our system, of course, and people submit reports through the system. But also, if people feel comfortable enough to go to their managers, sometimes our clients then will input those reports into the system just to have that record, so that for reporting purposes, it's easier to get a clear overview of where are those reports coming in from, are people feeling comfortable enough to go to their managers, are they reporting anonymously, and so on. So it just starts to build that clearer picture of what's going on within the organisation. So I think that's really helpful.
Yeah.
Great.
You mentioned, sorry, Charlotte, you mentioned email as a system. My personal preference is emails shouldn't be used for a reporting system. There are all sorts of peculiarities around it, and one of them being that email box is accessible by others other than the person receiving the report and the person making the report. You do get email compromise happening often in a lot of private and public sector organizations. So that's another aspect, data leakage because of that. So if you do use email as a reporting, just have a look at, how it works, who's involved, and does it stack up against what the law requires in terms of confidentiality and security. Just a little point I wanted to add in there.
Great, thanks, Kevin. Yeah, sorry, I didn't mean to mention email, but if I did, then great that you've clarified that point.
No problem.
Okay, great.
I see a great question. Sorry, I see a great question about the role of internal audit.
You read my mind, Kevin. I was just about to ask that one.
Yeah, I think it's a good question.
Okay, so the question is for everyone else. What role should internal audit have in an organization's protected disclosures policy and implementation? So take it away, Kevin.
No, 100%. I think, this is a control. Putting in a protected disclosure system is a control. And I do think internal audit does play a good part. They should be the independent party looking at implementation. Is it there in the first place? And then is it functioning according to what the law requires or what the policy says, in fact? And then, holding the management accountable. I think I think it should go on to the internal audit testing cycle. And again, I think it's also a good way of getting organizations to actually acknowledge that this is an area that's important. So I think, from my perspective, it should be something the internal audit looks at.
Maureen, did you want to add anything on that point?
Just from an internal audit perspective and from the confidentiality rules around protected disclosures, that of course then will link into the requirements for the system itself that you're dealing with protected disclosures to maintain confidentiality, anonymity where necessary, etc. So internal audit's role will be a role that of examining whether the system is operating as it is meant to operate. And certainly within the public sector, they would then probably be the department that would ensure that the annual reports, annual confidential reports necessary that need to be fed to the commissioner are actually happening. But all the time, you know, if you're looking at internal audit, normally when you're doing an internal audit, there's some element of sampling. You're not going to be able to do a lot of sampling. That's the one thing I would say, because you're not going to and shouldn't have access to the detail. So what you're going to be seeing is how many reports came in, how many of those resulted in investigations, whether investigations are open or closed. That's, in my opinion, the level of reporting that should be done, and that I believe is required by the Commissioner as regards the public sector reporting to him.
Great, thank you. I think we've just about got time for one or maybe two more questions. Let's see how we go. So next one then, how does the confidentiality requirement apply if the organisation subsequently identifies a legal obligation to notify an external law enforcement agency? So as an example, they become aware that an individual may be in immediate danger, something like that.
Yeah, that's a tricky one. I'm not a solicitor. I don't think I want to try and give a solid legal answer to that one. But I think, again, we go back to the possibility of this happening should be considered by most organizations, and it needs to be thought out and put into the policy. That's as far as I want to try and tackle that question, I'm afraid.
Sure, no problem.
Yeah, it's pretty broad, and there are a lot of different legal implications there. So yeah, like Kevin, I would be standing back a bit from that and recommend that, you know, if legal advice is taken, should it actually occur at the time.
Yeah,
no problem. Thank you both.
Yeah, I think overall, considering all of the nuances that your organization, depending on the industry and sector you're in, you need to think about it and not be caught out by surprise. That's just an overall recommendation. Consider what you do and the industry that you operate in, and then have a look at building the possibilities into your policy. Again, we go back to that. So it's all about thinking about what the law says and what you do and how you're going to manage all of the possible outcomes.
Great, thanks. Okay, I think we've just got time for one last question, so I'll be very quick. Maureen, this is something you touched upon earlier in terms of the feedback that needs to be provided to the reporter. What level of feedback needs to be provided?
Essentially, what you're providing is what actions are being taken as a result of the disclosure. So you're not going to be providing the person with details. You're certainly not going to be providing them with anything that might break the confidentiality of any of the persons involved, because don't forget, it's no longer just about the protection of the identity of the disclosure, but all the other people involved there. So it should be feedback on the level of, we have identified and agree that this is a protected disclosure. Therefore, these are our proposed actions in relation to this. And when it is finally closed out, the person should be informed probably to the level of, and it's very hard to say because each one is an individual case, but you are essentially saying that, you know, it has been confirmed that, yes, that wrongdoing did occur and therefore we're taking these actions, or on investigation, there are no grounds to actually substantiate this wrongdoing. So, but it will be quite different to each case, but I wouldn't be giving an awful lot of detail. One always has to consider the rights of all the people involved in an investigation, and you need to ensure that you have fair procedures in relation to everybody and maintain confidentiality.
Great, thanks, Maureen. And that really is all we've got time for today. So thank you so much to Maureen, Kevin and Raphael, our panelists. Thank you to everyone who submitted questions. Appreciate we haven't got round to answering all of those on here, so we will take the unanswered questions away with us and come back to you on those shortly. Just one last thing to mention before I do wrap up. So we do regularly organise a range of webinars, such as the one we're having today, and other events, and also publish content on various compliance topics. As well as a recording of today's session, we will be sharing the slides with you shortly. So if you do want to access any of that content or sign up for events, you'll be able to do so via the slides. So that just leaves me to say thank you very much for joining today and have a good rest of the day.
Thank you very much, everyone. It was very interactive. I enjoyed it.
Thank you so much.
Thank you.